Imagine this. In one hand, you've got the cutting-edge science of a giant corporation, and in the other, you have the ancient, time-tested wisdom of a farmer. Today, we're diving into a landmark Indian law that, for 25 years now, has tried to do something almost impossible: to balance both. And that really brings us to the core question of this entire explainer. How do you protect a company's billion-dollar investment in a brand new seed variety, while at the same time protecting a farmer's age-old right to save and share seeds from their own harvest? It is a huge, huge challenge. All right, let's get into it. We're going to start with why this law is even in the news right now. Then we'll explore the totally unique path India decided to take. We'll break down the delicate balance of rights it creates, meet the people who guard the system, look at the real-world challenges, and then finally, we'll ask, what do the next 25 years look like? So first up, why are we talking about this today? Well, because India is marking the 25th anniversary of a really groundbreaking law from 2001, the Protection of Plant Varieties and Farmers' Rights Act. We're just going to call it the PPV&FR Act for short. Now, to really get this law, you have to go back to when it was created. It's the turn of the millennium, and India had recently signed on to the World Trade Organization's TRIPS agreement. This is all about intellectual property rights, and it basically put the country in a global pressure cooker to come up with a system for protecting plant varieties. And this is where it gets super interesting. You see, the TRIPS agreement gave India a choice. It was a fundamental crossroads for how it would treat the very foundation of its agriculture: its seeds. India basically had two main options on the table. It could have just adopted the standard rigid patent system that, let's be honest, usually favors big corporations, but instead it chose a completely different path, something called a sui generis system, one that was custom built for its unique needs. So what on earth does sui generis even mean? Well, it's a Latin term and it literally means of its own kind. In a legal world, it's a custom-built solution. India basically decided that seeds were way too important and way too unique to be forced into a standard patent box, so it decided to build its very own box from scratch. And this custom-built system has one main goal: to create this delicate balance of rights, protecting not just one, but three very different groups who all have a stake in the seed. This image really shows the core idea perfectly. The Act tries to put the rights of the big commercial breeders, the scientific researchers, and the traditional farmers all onto a single scale, and then make it balance. Talk about an ambitious task. So let's take a quick look at this balance. On one side, breeders get exclusive commercial control over their new stuff to protect their investment. Makes sense. But on the other side, farmers get the right to save, use, and even share their own seeds, and they can even get rewarded for conserving traditional varieties. The key takeaway here is that both innovation and tradition are seen as valuable. Okay, let's dig into the specifics, starting with the breeders. The Act gives them some pretty strong commercial protections. We're talking exclusive rights to produce, sell, market, and distribute their new variety. This is all designed to encourage companies to invest in developing better crops. The Act also protects researchers. See, anyone can freely use a registered variety for their research or to develop other new varieties. This is so important because it makes sure that protecting one person's innovation doesn't accidentally block the next scientific breakthrough. It keeps the whole cycle of discovery moving forward. And now for what is honestly the most groundbreaking part: the farmers' rights. This act sees farmers not just as customers who buy seeds, but as innovators and guardians themselves. They can save and replant their seeds, they can exchange them, and they can even register their own traditional varieties. Get this, they're even entitled to a share of the profits if their traditional variety is used to create a new commercial one. The only major catch: they can't sell branded seed of a protected variety. Okay, so you've got this really complex system of balanced rates. But who actually makes all of this work day to day? Who are the guardians of this whole system? Well, that huge job falls to a specific government body: the Protection of Plant Varieties and Farmers' Rights Authority, or the PPV&FR. This is the official agency that's tasked with making the entire framework actually happen. You know, bringing the words on the page to life. You can pretty much break down their work into 3 simple steps. First, they register all the varieties in a national database. Second, they store the actual seed material safely in a national gene bank to preserve it. And third, they manage the National Gene Fund, which is what handles all the benefit sharing and compensation for farmers. It's a whole end-to-end system. But, like with any ambitious law, there can be a big difference between how it's written and how it works in the real world. This act is facing some pretty significant challenges on the ground.
The first hurdle is just how complicated the whole process is. To get a variety registered, it has to meet these really strict scientific criteria for being distinct, uniform, and stable. Now, for a small-scale farmer who doesn't have technical help, trying to navigate all that bureaucracy can be a massive barrier.
And the second hurdle? Enforcement. A law is really only as strong as its implementation, right? In a country as huge as India, a lot of farmers just don't know this law exists. That, combined with a lack of enforcement staff, means the Act's protections don't always reach the very people who need them the most.
This brings us to a really critical concern. There's a real risk that the very act designed to balance the rights could inadvertently tip the scales. The big fear is that large firms, with their armies of lawyers and all their resources, can use the system way more effectively, maybe even creating monopolies that hurt the same small farmers the law was meant to protect.
And on top of that, you've got other challenges. Things like disputes over how to fairly share the benefits, the potential loss of traditional knowledge if it's not registered, and even a risk that the system might actually slow down the spread of really important climate-resilient traditional seeds. So, after a quarter of a century, this act stands as a really unique Indian answer to a global problem. But as we look towards the future, the big question is, what's next? The path forward seems pretty clear. Most experts agree that to live up to its true potential, the system needs to be simplified. The institutions that run it need to be strengthened, outreach to farmers has to be expanded big time, and maybe most important of all, that promise of fair benefit sharing, it has to be fully realized. Which leaves us with one final and pretty powerful question. For 25 years, this act has tried to protect seeds and people. But now, as we face these growing challenges from climate change and food insecurity, can this unique Indian model evolve to not only protect rights, but to protect the nation's future food supply itself? The answer to that will define the next 25 years.